time for all your binge-worthy pop culture news. Welcome to Up and Adam.
Hi, guys. Welcome back and happy Wednesday. As you guys know, today is the fourth part of the Real Housewives of Beverly Hills reunion. So in true Real Housewives of Beverly Hills fashion, we have to talk about Erika Girardi, and who better to do that with than attorney Ronald Richards. Guys, if you haven't already, go ahead, smash that like button. If you're not subscribed, get subscribed, as this is a subscribers only live chat. And let's welcome Ronald. Good morning.
Hey, good morning, Adam, and good morning to everyone else that's listening today. How are you?
Good. We were just talking about this. Busy, but I'm sure I don't hold a candle to your workload, so I'm not complaining.
Well, hard work never got anybody into trouble, typically. So this will be my only live broadcast and my only broadcast on these subjects that we posted today on our Twitter feed. Just like a press release, but commenting on things going on in the court at Ronald Richards. And as a reminder, the views are our own views and not the views of our clients. Right.
Well, and I know that you have a few tweets that came out, but I did want to ask you before we get into the tweets. There was an article that came out that said that Erika Girardi's husband, obviously Tom Girardis' bankruptcy, is in danger of being tossed out of the court due to alleged fraud. And then they were sharing with us that there is over, I believe it's $261 million reported in a statement signed by Girardi, 89 in real estate property, 116 million in cash, 44 million in securities, and 12 million worth of jewelry. What does this mean for the bankruptcy to be thrown out?
Oh, that's a good question. I actually did post that motion. Basically, what everyone needs to understand, there's two ways to file what's called a Chapter 7 bankruptcy. 95% of Chapter 7 bankruptcies are people have too much credit card debt and revolving debt, and they just need a fresh start. That's a typical bankruptcy in America. So what happened is, in this case, it wasn't voluntary initially. Some of the petitioning creditors were creditors, apparently, of Tom Girardi. So they petitioned the court to basically put him into a personal bankruptcy, and then the person that petition is directed toward has an opportunity to say, wait a second, I got plenty of money, I don't want to go into bankruptcy, and they oppose it. And they say all these debts are disputed. In this case, Girardi just basically capitulated and agreed to the bankruptcy, so to speak. So then it becomes a normal bankruptcy. And so what happens is, if no one did anything, all the debt that Girardi owes would be what's called non-dischargeable. It would be dischargeable. It would be done, like flushed away. So if he owed $50 million, it would be flushed away, like just basically like it never happened. So what the trustee in that case did is he said, wait a second, this guy is not giving me any records. He's not cooperating. Of course, he has dementia now. There's a probate case, and he shouldn't get a discharge because he's not provided us any transparency into his finances. So what he's trying to do is basically say, look, when this bankruptcy is over, he's still going to owe all the money to the victims, all the money to these creditors. He's not going to be able to walk away and get a fresh start because he's not operating with transparency and in good faith. That's basically, in English, without getting too lawyer-like, what's going on.
So does the trustee really believe that he still has $261 million in assets?
No.
Okay.
No, I don't think anybody believes that he has that kind of money. Of course, we're investigating and we're getting complete cooperation. We'll be able to know if there's any money that is being held by somebody or by a third party. But I mean, it's obvious if you look at just even what has been filed publicly that there was a lot of money spent on lenders, lifestyle. So probably, I mean, most people don't hit their 80s as a successful lawyer and want to end their career like this, in the sense that obviously there was a spending and expense problem, and it manifested itself in two dueling bankruptcies. So I think right now, they're just going to check and see if there's any other hidden money, and this also protects the estate that if there is some hidden money, they could always go after it because there's no discharge.
Okay, so my next question for you is then, obviously, Tom Girardi, if he's not cooperating, can't they just chalk it up to, okay, well, he's, he has dementia and Alzheimer's, so he can't really cooperate, instead of, couldn't they look at it like that instead of just throwing out the bankruptcy altogether?
When you say throwing out the bankruptcy, who would you be suggesting wouldn't cooperate? Just rephrase that question so I can understand it.
Tom Girardi, we're hearing that, you're saying he's not really cooperating with everyone. He's not being transparent. He's not sharing, insight into his finances, but also he's under a conservatorship.
Yeah, but his conservator doesn't really have the access either. And let's just for a minute pretend and take at face value that his brother, who's a dentist, thinks, well, my brother is losing his marbles and I'm getting him a conservatorship. That doesn't mean he knows every single thing about Thomas Girardi's personal finances. So the trustee really doesn't have a good way to get this information. And whether Tom Girardi's intentionally stonewalling or because of the dementia, it doesn't really matter. He's not being transparent. Again, everyone likes to focus on intent. Bankruptcy just focuses on results. Are they getting the information they need to see what the account looks like? And the answer is no. So whether he's doing it on purpose or not is irrelevant. What is relevant is the motion has merit because there's no way a trustee Rund could come up with the information he needs to justify a discharge for Mr. Girardi. And remember, I have nothing whatsoever to do with that estate. That's not my estate that I'm involved in. This is his personal estate. And so he's just basically covering himself correctly to say that, look, this guy's not going to get a pass or a wash here of all of his debt and not show us the goods, basically.
Okay, that makes sense. And then before we get to your tweets, because I know that you were pretty active on Twitter this morning, there was another article that came out that said Erika Girardi tells the judge that her husband, Tom Girardi, was solvent when he spent millions on her and demands the $25 million bankruptcy suit be tossed. Being solvent, does that make a difference?
It does. Respectfully, it doesn't make a difference from her perspective in the court on certain of the claims. It does make a difference if the suggestion is that she received money and that made him insolvent. That's like a fraudulent conveyance, but that's not our theory and the only theory of recovery. As I've repeatedly said, we're simply just trying to right the scales here and say, look, all this money was diverted from the law firm and paid a bunch of personal expenses. These weren't law firm expenses. Let's work something out and give it back. By the way, that claim is totally dischargeable in a bankruptcy. So I have no interest looking out for the estate to push someone to basically file a legitimate bankruptcy. I don't want that to happen. I just want to resolve that matter. So because that's what's in the best interest. If you push too hard, nobody has any hope. But that's a fair statement if you narrow that to only the fraudulent conveyance claims. Because if I give you money, Adam, but I still have millions of dollars in the bank, that's not a fraudulent conveyance because I'm still solvent. That's where that's coming in. If I become insolvent and I give you all my money, then that's a potential fraudulent conveyance, and there's up to like a 4-year clawback. And if there's an IRS claim, it could go up to actually 10 years. So it's pretty broad. It just depends on the facts. But again, a lot of people like to take facts in isolation and not look at the big picture because they don't really know the case that well. So that's why you see a lot of misguided commentary out there.
Okay. And I want to move over to your tweets from this morning because, again, you did have a few. And I want to go through them and see if you can't walk us through exactly what these tweets mean. Okay. All right. So the first one.
Just to give people some background, that's not my, I think we should go to the earlier tweet. That looks like the latest tweet, but where I posted the answer. But just to give people, no, not that one. It would be the first one. No, you go back to the answer, the very first one this morning. But just to give people, to remind them about background, Twitter is not social media. You can follow our Twitter page at Ronald Richards, and you get all the receipts, and we post things. It's not us. We're just posting documents and giving you our view of what the documents could mean to the other side or could mean in the case. But Twitter is simply a mechanism to put things out there so you, the followers and the viewers, could just easily download it. This stuff's uploaded to a platform. We have journalistic credentials on the platform, and simply we're just giving you information and documents that are easy for you to read. It's not social media for us. It's just a way to communicate with a bunch of people that are interested, and then they ask us questions, and we think it's a great way to talk to people across the world.
Okay. I'm going to go ahead and bring up this first tweet. You said there are a lot of filings to process from Erika Jane. First, here is the answer from all three defendants to our complaint. The answer puts the case at issue for further proceedings to set dates. The answer admits or denies the allegations. Okay.
In the complaint. Correct. And by the way, sometimes people think I have typos. Yes, sometimes I do if I'm rushing or in the car or in court. But other times I have to abbreviate because I try to put it all in the same screen. So I apologize to everybody. I sometimes am fumbly with my fingers, but sometimes the abbreviations are intentional. But what I wanted to know, and a big shout out to Kempire, hope he got back safe, and wanted to go over the answer. In a case, as everybody remembers, a couple months ago, we filed a complaint and then a first amended complaint, sort of saying this is our story of recovery. And then because there's an extreme amount of collaboration and cooperation from Erikas Lawyers in a completely civil and professional relationship, we basically, after going over a bunch of different things, making modifications from the complaint to the first amended complaint, and not wasting a bunch of resources on what we call pre-complaint motions, they filed an answer, which basically puts the case at issue. And then they go down from the case and they basically say, hey, we agree with this, we disagree with that. And that lets the judge know, he doesn't really read the complaint or answer, so everybody knows he's not sitting there reading this stuff, but it lets the docket know what's at issue. So if they deny something, that means we're supposed to be, that's going to be an issue in the case. And then they admit or deny, or they give explanations, and it kind of gives you a view of what their defenses are going to be. Then they assert a bunch of defenses. And so by doing this, the case is now at issue because it's sit around for a couple months. We do want to move the case forward. Again, we're very hopeful we'll resolve the case. We don't want anybody wasting any more hard-earned money, post-separation Housewives money on lawyers. No, believe me, no lawyer here on this particular case wants to waste their client's money. We want to do it in the best interest of the client. So this answer was filed, and that kind of sets the stage for our November 16th status conference, where the judge now knows, okay, these lawyers have been talking, and an answer is filed. So that's a statement that, hey, the parties want to move the case forward. That's why the answer is an important document. It's just an answer to an unverified complaint, and now we're moving forward. And that was the first important filing of the week.
Okay, and then your next tweet was, this is the joint status report in Miller versus Girardi. This is filed before the status conference, which is on November 16th, 2021. It tells the judge what the parties have done. The attorneys work together to create the report and provide the judge an update. That's pretty much what you just went over.
Well, I was describing the answer, and then this is actually a precursor to the status report. To the status conference. And so when all of you have an opportunity to read it, what it does is it shows the defense side and the plaintiff side, and there's a bunch of boxes that are checked. And then in this case, there's actually was a lot of additional work by Erika's attorney and his great support staff, and they put some additional positions in there to basically explain to the judge why we haven't had a more thorough conference, because we were working out issues in the answer. It's all in the status report. And it basically tells the judge to set another status conference December 7th or 8th so we could have a more formal conference. And then the judge will issue basically what's called the discovery order and set dates. So these are just normal things, and why it's so important that the lawyers need to be working together professionally and civilly and talking about the issues, because the court appreciates good lawyers narrowing down the issue, so we know what's at issue. So this report is, again, a symptom of we're moving the matter forward in a pace that is going to lead to some sort of resolution within the next year or less, because now the judge is going to say, okay, I see all the issues. There's a box in there about mediation. We checked, we were okay to go to mediation. They said not yet. That's because there's more discovery they may want to see. Like I've repeatedly said, we're sort of at the end. We sort of know what we have as the evidence, and now we just want to make sure they got all the information they need, so they're ready to see what issues they really want to try or resolve. And that's how a normal professional civil case is handled.
All right. And then you had 3 more tweets that I want to go over really quick, because when it comes to Edelson, well, Jay Edelson from Edelson PC, these got me interested. Sharing agreement between Edelson and Girardi Keese, which will require that the Illinois litigation be dismissed, in addition to exposing Edelson to discipline by the State Bar of Illinois and California. Does Edelson have agreements signed by the former Girardi Keese?
Yeah, if I were you, I'd start at the first tweet. That's the last tweet. It was a 3-part tweet, all connected. So maybe go to one more up, please. Sorry. Yeah, that's perfect. Let's start there, because otherwise I'll get confused. It's too early for me. All right.
So yes, guys, it is 7 a.m. over there on the West Coast. All right. So Ronald Richards breaking the bombshell filing of the day in the Tom Girardi estate bankruptcy is Erika Jane's supplemental opposition. It accuses the Edelson firm of an illegal, unethical fee sharing agreement with Girardi and suggests it exposes them to discipline. Here is the document.
Okay, so to me, this was a bombshell filing because, one, to be very clear, it's filed in the Thomas Girardi personal bankruptcy estate, and my comments are just directed toward the publicly filed document. That's it. I mean, it is newsworthy. So as everyone knows, the Edelson firm did a great job of exposing Thomas Girardi in Chicago, and they brought initially a contempt case against Girardi for refusing to turn over $2 million in fees that were owed to the clients. And the Edelson firm has consistently said, and I absolutely believe them, that all monies coming in will go to those clients first, and they've worked pro bono to try to get Girardi to pay. So this has nothing to do with the work they've done in the past or their motives, etc. However, you do need to realize when you sue somebody, and they're not suing me or the trustee, they're suing Erika Girardi, and she's entitled to put on a defense. And we expect her to put on a defense in our case too. That's the system. But what was so significant about this filing was that, one, there's a pending motion to sort of get relief from stay to move that case to Chicago with respect to the lawsuit against her. So I'm not going to get into the entire merits of that, because I think we discussed it about a week or two ago. There were some oppositions. I just want to focus on this filing. This filing, there's already opposition by the trustee in our case, saying that the case Erika shouldn't have to fight 2 cases, that there's no basis to move the case to Chicago with respect to their claims, which are really just for their attorney's fees. And so that's sort of the genesis of how this kind of disagreement started with respect to this one narrow issue. So oppositions were filed a week or two ago, and then the matter was continued. So then apparently Erika's lawyers looked at some additional facts and filed what's called a supplemental opposition. And the reason why this opposition was so significant is because they have allegedly exposed a problem with the original Boeing clients that Edelson was involved with. And so let me just break this down for everybody. The case that in all the cases that I've ever seen for Girardi, he's the primary lawyer, meaning he brings in the clients and then he brings other lawyers to basically divvy up the cases. So basically they do a joint case. You understand that, Adam? Like you see yes. Girardi, then another law firm. So, and that's because Girardi doesn't have an office in Chicago. So they probably said, hey, we need an Illinois lawyer because the Boeing case, Boeing's based in Illinois, was going on there. So they brought in Edelson's firm to basically help out on the case and get a portion of the attorney's fees. So that's sort of how the table is set here. And Girardi did this across the country. It's very normal in the personal injury business, mass tort business, for the lawyer that gets the case to refer out to another lawyer, and then the client signs a document called a fee sharing agreement that has to be signed by the client. And that's the law in California. Happens to be the law in Illinois too, may even be stricter in Illinois, hard to say. But basically they have the same rules. And that's because lawyers can't do things behind clients' backs. The clients have to agree to everything and approve everything in writing. And there's disclosures that are required. So what happened in this case is Keith Griffin had sent a letter to Edelson's firm saying, hey, this is how we're going to split up the fees. And that letter is part of the claim that was filed in the bankruptcy case by Edelson, claiming that they want their fees. They don't represent any clients anymore in the case. Those clients got new lawyers because of the conflict, because they were tethered to Girardi. Edelson was. So they decided not to be involved in any further representation. Those clients got new lawyers, and that's who they're pursuing their contempt claims and other claims. So what happened in this case is Erika's lawyers said, hey, wait a second, attached to this claim, there is no signed agreement with these clients, which are all in Indonesia. All right. So there's no way these clients sign more retainer agreements. You know, I just don't see that. Especially, right. Otherwise they would have been placed on the claim, presumably. And so they're like, wait a second, where are the signed fee sharing agreements? Now, lawyers in a lot of different types of cases could get away with things like the rules aren't so hard and fast. But what is hard and fast is the law on fee sharing. If you don't have a correct fee sharing agreement with the client, the lawyer that received the referral cannot get their fees. That's an illegal agreement, and they are not allowed to get the fees from the client. They could only maybe pursue a claim against the lawyer that referred them the case under a different theory, but that's a claim that is untested and will need to be adjudicated in a separate hearing. So I just wanted you to understand why this is so significant. Is they basically said, look, all these claims that they're suing Erika and these other defendants on are based on an illegal fee sharing agreement, so they have no right to get any fees as to a specific amount. And Keith Griffin actually raised this. He's a former Girardi associate. He actually raised this in the Illinois case, but the judge hadn't ruled on it yet. And he's the one sending the sort of attorney to attorney letter agreement, which just does not comply with the rules. And I think they were surprised to see that, you know, this firm, out of all the firms, has this potential issue. And so that's why I think they've raised it, and they're going to have to address it in the reply brief. Do they have agreements signed by these clients that predate their lawsuit? I mean, this is a big deal. We're in a post-Girardi era. I mean, to not have things consistent with the rules of professional conduct is a significant issue that is going to be examined. I think there's a question up here from Hamilton.
Yes. Question, what is the status of the third motion for Ronald Richards' removal by Erika Girardi? Have documents been provided, or is it on hold until the ruling on this motion? Thank you.
Oh, okay. The appeal of the denial of the motion for reconsideration seeking my removal, my firm's removal, is just up on appeal, but they've extended the deadlines to actually designate the record a few times. If that appeal isn't dismissed, then unfortunately we would move to dismiss it and have to have a more less collegial and collaborative role, which I'm hopeful that it'll just be dismissed, because I really don't think there's grounds for the appeal. The judge sustained all the objections to their evidence, and the appellate court would have to find that the judge abused his discretion and made clear error, which is an extremely hard standard, Adam. I memean, without any evidence, there's nothing to appeal. So I don't want to really get into the appeal, but the bottom line is no, it has no effect on the case. There's no stay, and it's just, and the appeal was initially done, which is okay, to preserve rights, but that's why we've been talking about it. Is it really worth going forward on and making us spend money when we're trying to save money, and we also save her money by not engaging in expensive discovery? So we're trying to all work together to preserve resources. Her only source of payment that I know about today is the money she's making from the Housewives. So the more that goes to lawyers and accountants and expenses, the less money there is to resolve the case. So that is a reality that I am dealing with. This doesn't prevent me from looking into see, is there any money being held by a third party? I will never resolve the case until I'm satisfied that there is none. But that doesn't mean that that may be the outcome, that all the money was spent and that she has what she has, which I know about, which is a little bit more than zero, but nothing to write home about. Plus she's making a nice salary from the Housewives. So I got to deal with that reality. And that's why we're balancing up. But I'm not losing sleep that in a year from now, there's going to be a ruling that I'm off the case. And then I would appeal that to the Ninth Circuit. So, I mean, this would go on for years. This case will be well over with, in my opinion, before that ever reaches a ruling. I mean, this is honestly a big side issue. I think we're way past that. And
it's almost a waste of time.
It's a total waste of time because the record shows, 20 plus stipulations with her lawyer. How could she suggest that I'm biased or unprofessional? I mean, we're both very professional with each other. I mean, and look, I'm representing the trustee. I'm representing the trustee who represents the creditors. I mean, I have to call them the way I see them. Most of the time, it's very clear. All the money was spent, in our case, we believe was spent on Erika's expenses. I think I'll be able to prove that. But that's, again, a ridiculous number, $25 million. Right. How are we going to do that? I mean, that's no one's paying that back with one check. I mean, it's silly. You have to give people hope to settle a case, or you never get a settlement. You just get a bankruptcy, or you get, a bad outcome. So that's where we are. Okay, go ahead.
Okay. Before I bring up your last two tweets, and Michelle Salas, thank you so much for the question. Why is Erika's lawyers arguing Edelson didn't sign agreements, re-client fees, but then argues Erika didn't know the agreements she was signing? How can they use that argument when it goes against Erika Girardi?
Well, and Michelle, that's honestly two different things. Erika, in California, if you sign an agreement, you're presumed to have knowledge of the facts and the agreement and the terms. So everybody always says that, oh, I didn't read it. Well, you can say that, but it doesn't work really well when you go to court. In this case, her lawyers are saying that the clients had to sign consent agreements to share the fees, and they don't see any consent agreements, so therefore they cannot sue for a breach of a fee agreement for fees because there is no client written consent with all the other bells and whistles that the ethical rule requires as far as disclosure. So they're not inconsistent in their argument. I mean, and by the way, lawyers are held to a higher standard when it comes to fee agreements and rules. Okay, for example, everyone should know that if you don't have a written fee agreement, that's why I love doing this on your show, Adam, because I want people to know their rights when they deal with lawyers. If a lawyer says, I'm going to take your case on a contingency, and you don't get a written fee agreement with certain language in there, it is unenforceable. You could just basically make the lawyer do all the work and at the end say, give me all the money. You're not taking your percentage now. It has to be in writing. So in California and in most states. So I will tell you that in this case, there is no it's black and white for lawyers. Lawyers can't go to the judge and say, I didn't follow what I'm supposed to follow. It'll either be there or it won't. I don't know. I mean, I'm sure they're going to have some argument as to why there's no written fee agreements with the clients, that they're claiming they're entitled to a percentage of the Girardi fees, but we'll see. I mean, I don't want to prejudge something, but it's going to come out in a week. We'll find out.
Right. Okay. Well, let's get back because I know some other people post questions, but I do want to go over your last two tweets. Let me go ahead and take this down really quick. This comment. Okay. Specifically, the evidence undisputably shows that the Illinois investigation to collect attorney's fees allegedly due, which Edelson seeks relief from stay to pursue, is based on an unethical, unenforceable, and illegal fee, and unethical, unenforceable collect attorney's fees. Okay. And then I want to bring up this last one. Sharing agreement between Edelson and Girardi Keese, which will require that the Illinois litigation be dismissed in addition to exposing Edelson to discipline by the State Bar of Illinois and California. Does Edelson have agreement signed by the former Girardi Keese clients? That's crazy to me, though, just because of, the documents in the fee sharing that could totally just have everything on Jay Edelson's side. It's like, doesn't matter.
Well, let me tell you where this comes up. Yeah, by the way, I think you said investigation, but it read litigation.
So litigation, sorry.
Yeah, no, that's okay. Yes, typically the referring attorney, if the attorney that is receiving the referral doesn't follow the rules, years later, this is a common defense that the referring attorney does. They basically say, look, you didn't have our client sign the fee agreement, so we're not paying you your percentage. We can't. It's against the rules. And then the attorney that didn't get, the signature on the retainer agreement, that attorney is out of luck most of the time, except for maybe for the work that they did, and they could only get it back from the attorney that referred him the case, but not from the client's fee. They'd have to bring a separate claim, which is a big headache. And so it's a defense that's used. It's buyer beware. I mean, it happens. But it would be amazing that in this case, where sort of Edelson has sort of set the standard for, what's good in the world about attorneys, that how is this, what's their explanation for this? I mean, I'd like to hear about it. Again, I'm not judging it. I just think that they raised a point that is fair from the evidence presented in the claim. You would think in your claim, if you had fee agreements signed by the clients, those would be front and center, not the letter agreement. And I've never seen any other agreement signed by clients. So I don't know I'll have to see what their response is.
Right. Okay. Melissa B has a question. Can EJ Global file bankruptcy to make this all disappear for Erika?
Not really, because EJ Global is 100% owned by Erika. But Erika could file bankruptcy and make it all disappear. I mean, I'll tell everyone right now, if Erika filed bankruptcy, I'm not suing her for fraud. There's no fraudulent conveyance. I mean, these professionals did the tax returns. The professionals and Thomas Girardi handled the books of this law firm, and Chris Kamen's the one that asserted the fifth. I mean, I'm not going to go on a total waste of time. I don't think I'm ever going to get there, Adam, because why would Erika want to file bankruptcy? She has great credit. She's going up in the world now that she's away from Tom, not down in the world. She's getting a raise. Why file a bankruptcy when I'm trying to come up with a reasonable outcome here that everybody wins, so to speak. But it's never going to be $25 million because that would take her the rest of her life to pay this. And the law doesn't require someone to be what's called an indentured servant to a creditor. I mean, the most you could ever get on someone's wages is 25%. And I don't want her to do that. I want her to basically resolve the case because that's what's in her best interest. I mean, put it behind you.
So that's interesting because a lot of people on Twitter and Instagram, all over the place, who are chiming in about the Erika Girardi and Tom Girardi legal scandal. Now it's kind of looking that like Erika, like there is some sort of light at the end of the tunnel for Erika here, because we all heard this, insane number, this whopping $25 million number when it came to suing Erika. And now we're hearing, okay, well, she most likely won't have to pay anything close to that because there's no way that she'll ever come up with $25 million anytime soon. So the point here is to get to some sort of resolve and figure out what can she pay. That way we can move forward and put this behind us, but that could be significantly less than $25 million.
Well, obviously, I mean, she spent this money. It's gone. I mean, I've seen it spent with my own eyes. Kempire want to know, can she file for bankruptcy even if she claims she has nothing to do with EJ Global? I mean, she is EJ Global. It's called a personal services company. It's filed under 1040. It's not her personal return. It's just a holding company. I mean, of course, their position is, hey, EJ Global owes the receivable, not Erika. Okay, but I mean, it's the classic alter ego. EJ Global had no assets. So it's one and the same, in my opinion. But again, it's funny money. Nobody's writing the estate a check for $25 million that they don't have, and they have future income of whatever it's going to be. That's not how you get money in the door. You get money in the door by looking at the person's ability today, and do they have a desire? Of course, Karen Everston said, of course the Range Rover's leased. Duh, I agree with you. I mean, these are all smart people that always watch the show. I mean, a leased car is a liability, not an asset. And the assets that she does have are assets that also come with what's called exemption. So look, it's not that I'm cozying up with her or I've changed my view. It's simply we want to get real. We want to make a deal that makes sense for everybody and doesn't. If I got a $25 million judgment, she would be what's called insolvent. And then some other creditor may put her into bankruptcy. I mean, it just doesn't, it's not realistic that we're going to go down this road. So I want to cut our exposure and cut her exposure and do what's best for the estate and the creditors and get money in. I mean, by the way, I have a lot of other targets. I have professional targets. I have a lot of people, by the way. The good news is this investigation has showed me who really are the people responsible for this, and I'm hopefully going to get the green light to come after them. So I want you to know there's better targets with insurance. I have richer people that have exposure here. So, and if you saw, the trustee filed a motion to have another lawyer from her firm, very good lawyer that I've worked with, Dan Lev. He's coming in to pursue some adversary cases. And you're going to see, once that motion's approved, there's going to be a bunch of new lawsuits coming against a bunch of people that you recognize. And that's easier low-hanging fruit, so to speak. Like they have the money, they can pay, and they don't have a defense. That's fraudulent conveyance claims. Like pure, hey, they got money right before the bankruptcy, they got to return it. So those are claims that are commonly brought in a bankruptcy, and those will result in resolution. So it's not all about Erika. That's just one person. We have a team of lawyers looking at 50 different targets, not just her. So we can't just spend time all day long on her. You know, we want to get as much money as possible from everybody, if that makes sense to you, Adam.
Absolutely. And I think my last question for you, because I know that you're extremely busy, but I do want to ask this because I know I'm going to get a lot of it in the comments. If you do go ahead and come up with some sort of settlement deal with Erika, no matter what the number is, let's say it's even 5 million out of the 25 million, everyone believes that your pay is based off of commission for what you find, like if there are hidden assets. And I'm sure people are going to ask, if you come up with some sort of deal, will you end up walking away with it or away from this without making any money?
No, because the fee structure is whether I get it voluntarily or involuntary. I mean, 99% of civil cases, by the way, are settled voluntarily, not involuntarily, because then you have no control over the case. And in this case, I may be working on this case another year, and if I don't get a voluntary settlement, then it could be another year after that, and I may not get anything. But I mean, the issue really with respect to a settlement, I want everybody to know it's not what we call a done deal. It has to be filed in open court. And if you, not your viewers or the followers, but like if a creditor thinks the settlement is too low, they have a right to outbid the settlement. I don't know if you knew that or not. They could say, you know what? Erika's only settling for, let's say, $1 million. I think the lawsuit against her is worth $1,001,001. I will pay that to the estate and take over the lawsuit. They're allowed to do that.
Oh,
I didn't know if you knew that. Yeah, oh yeah. Creditors can object. There's checks and balances. This is a transparent process. So no one's going to settle for something that is not going to be past the smell test. But in the almost 30 years I've been doing this, I've never seen, like on a real number, another creditor say, you know what, I'll just give the estate money and take over the litigation. So I just want you to know, Adam, there is many safeguards on what we call a low ball, backdoor, sweetheart settlement. Whatever settlement we make, all of you are going to get to see it. I'm going to put it online. And if someone that's a creditor that has standing, like a victim, a bank, or a lender, or anybody else that's in the case, if they think there's something wrong, they'll let the judge know, and then they'll put their money where their mouth is. If they don't want to pay anything, they're not going to have a lot of, you know, the judge won't find that persuasive. In fact, this judge has asked me many times, is your client willing to put up the money if you don't like this deal? And I would always have to say, no, we just don't like the deal, but we're not willing to put up the money. So that really is the driver. And so that's what will happen here. One person named Felicity Suarez said it feels like Erika is working with us and gave us other targets. That I appreciate optically that's not accurate, but it's a fair statement. I just want to address it. We would love cooperation on some of these other targets, and the only way we're going to get cooperation is by resolving her case. Okay, we can't be suing someone and aggressively pursuing them with tenacity and need their cooperation. We don't need to horse trade it either. One really has nothing to do with the other, but of course, I want an insider's view as to what these professionals did to these creditors. I mean, you need to realize Erika and Tom did not prepare their tax returns. Erika, and especially, was not the CEO of the law firm. Erika did not sign clients up or run the trust account. Okay, that was not what she did. So we just simply need to do what's correct and fair and smart and reasonable, which brings in a recovery. I've, tried many different ways. Just blindly litigating against someone is not smart. It's just, I don't know what it is, but it's not the way I do things. I want to simply get a recovery and then go after other people and get some assistance that they were the responsible parties. I mean, it's very obvious, but I already know who those people are. I mean, it's from my own investigation, and I will get assistance where I need it.
Got it. Okay. Yeah. All right. Well, Ronald, I know that we're already at 41 minutes, and I know that we don't like to keep you over 30, 45 minutes because you're always so busy. So thank you again so much for coming on and sharing about your tweets today. And of course,
I do want to say one thing to Karen Everston. Miss Everston, I want to tell you that absolutely, I am not settling this case until I confirm that the person paying the expenses is not someone holding money for Tom or Erika. Okay, so that's not even an issue. There's full cooperation on that. Look, people have friends in this world that help you out. And from watching the show, I mean, there's a lot of friends out there that have money. Okay, and I'm not interested in embarrassing someone that's legitimately helping another person. I just need an affidavit or my own investigation, and that's sort of life in the big city. I mean, some people have sometimes tens of millions of dollars, and they will help out someone that they think is newsworthy, famous. I mean, that happens all the time in LA, and I don't think it's illegal or problematic. I just need to verify it.
To be fair, Sutton on the show even asked her if she needed to borrow some money. So it's like you said, it's not like it's unusual.
Yeah, and these women like each other, Offset. And I mean, look, look, there's a lot of women who I've represented their husbands' businesses or done business with them on that show. And I could get a call one day and say, look, we're paying the fees, okay, because of A, B, and C. And I'll sign a private declaration under penalty of perjury, and I'll drop it because it wouldn't shock me in this case. I mean, think about the 20 years of friendships those two developed with all sorts of people. I mean, we're not talking about $10 million. If someone floated them $500,000 for a legal defense fund, it wouldn't shock me. Okay. Right. It just wouldn't, because we're dealing with an unrealistic, I mean, look at the stuff these people spend money on. It's not stuff you and I would spend money on, Adam. So it wouldn't shock me if someone felt like, hey, I want to help out a person on the show. And so that will be investigated, and it is being addressed, and nothing will be done until we're done. So I just want everyone to realize that we will never compromise those values, but we also need to be realistic. And by the way, anybody could always contact me on Twitter. You don't need to ever let a third party that is not involved in the case just opine. They don't have like a special insight. If you want to know, if you feel like something we've done questions our integrity or our positions, all you got to do is DM us at Ronald Richards on Twitter, or put a public reply. We try to reply them, and we will answer you. Just no vulgarity, like Adam's rules. Just be civil, nice. We're not here to fight with anybody. We're just doing a case. That is very interesting, in that the best result of this case, hopefully in my mind, will be no other American citizens will be victims of a crooked attorney. That's why I like this case the most. It brings out the best, and hopefully people will never have this happen to them again. I get a lot of emails all the time from people that their attorney's not doing something right, and I guide them in the right direction. and I do answer questions. We try to do them on Instagram too. I don't typically run that all day long, but I'm pretty good on my DMs and on my Twitter. So follow us. And Adam, we come on the show to do a live feed so people can listen to the replay and I don't have to repeat myself and it's more personal. So hopefully that gives everybody what they need. And Adam, again, thanks for getting up with me and doing this.
Yes, of course. And guys, you can also find Ronald Richards' handles inside of the description of this video. So if you guys want to go follow Ronald Richards and get an update, absolutely go check him out on Twitter and Instagram. And like he said, just DM him. If you have a question, DM him and someone from his team will get back to you. So Ronald, thank you so much. I know it's early over there and I'm sure you have a busy, busy day as it's only Wednesday, which blows my mind. Thank you again. And we do look forward to having you back when more news, more information comes out.
Okay, thank you.
Thank you, Ronald. All right, guys, that was Ronald Richards. Go follow him on Twitter at Ronald Richards. And also, again, check out the description of this video. Guys, thank you again so much to all of our mods and everyone in the live chat. It's a subscribers-only live chat, so if you're not subscribed, get subscribed. We're about to go live on Jason's channel, Down with Jason, to talk about Vanderpump Rules at 11:35 p.m. Eastern Standard Time, or a.m. Eastern Standard Time this morning. This is early for me too. I have to go get some coffee, but guys, thank you again so much. And don't forget, we have Hot Messy Topics tonight at 6 p.m. for another subscribers only live chat. We will be back tomorrow to talk about the Real Housewives of Beverly Hills reunion part 4 with a very special guest. I appreciate you guys. And thank you, Ann Michelle, for the super chat. And we will see you so very soon. Actually, we'll see you in less than an hour on Down with Jason. Bye, guys.